thank you very much for joining us. I know for a lot of people this was on really short notice, but we have a great set of panelists here for you. I'll introduce them one by one in a moment, although they are well enough known in their profession that I suspect a lot of you know these names. My name is Carter Doherty. I am the Communications Director for Americans for Financial Reform. I used to be a journalist covering the CFPB, and now I help to defend the CFPB at AFR. And this is the latest iteration of a fight that a lot of us have been fighting for the better part of 10 years. As you all know, the Fifth Circuit last week dealt a blow to the attempted to deal a blow to the agency under the pretext of attempting to enjoin part of a CFPB rule on payday lending at the behest of the payday lending industry, of course, that the Fifth Circuit also pulled out of its back pocket that the CFPB's funding mechanism is unconstitutional. And this is something that our coalition has worked on for a long time. The AFR family, the big 200 plus groups that work on CFPB issues. And as many of you know, the CFPB is funded through the Federal Reserve, and the Fifth Circuit decided that somehow that ran afoul of the Appropriations Clause. This is no small challenge, even for skilled lawyers, I am told. But fortunately, we do have with us one of the more skilled lawyers around. And so we're going to begin with Deepak Gupta. Deepak is a increasingly seasoned, I will say, appellate and Supreme Court practitioner. He I'll say, shot to prominence when he argued a case on forced arbitration before the Supreme Court a number of years ago, and now then founded an appellate boutique called Gupta Wessler. And amid all of that, he managed to work at the CFPB for a time as well. And he's going to kick us off here by talking a little bit about what I will somewhat glibly call the legal insanity of this decision, but it's not far off from the truth. So, Deepak, why don't you take it away?
Okay, great. Thanks, Carter and Americans for Financial Reform, for inviting me. And it's good to be here with Dale and Kathleen as well. I'd like to make a few points today, and then I'd be happy to answer questions in the Q&A. The Fifth Circuit's decision, as Carter said, the decision striking down the CFPB's funding structure is aggressive and extreme. It's unsupported by the Constitution's text, structure, purpose, or history. It contradicts the decision of every single previous court to consider this issue, and it threatens to produce legal chaos in the consumer financial marketplace if it is not stayed in short order by the US Supreme Court. The Appropriations Clause of the Constitution says, and I'm going to quote here, "No money shall be drawn from the Treasury, but in consequence of appropriations made by law." For 200 years, it's been clear that the purpose of that clause is to make sure that Congress controls the purse strings. So for example, the president can't go out and spend tax revenue on something unless Congress gives him or her permission to do so. But the clause has never been used in the way that the Fifth Circuit just used it, which is to prevent permanent ongoing appropriations or to prevent self-funding by agencies. The Fifth Circuit is invoking the clause to do the opposite of protecting congressional prerogatives. Remember, of course, it's Congress that set up the CFPB in the Dodd-Frank Act, and it's Congress that devised the CFPB's funding structure. So what the Fifth Circuit is saying is that the funding design that Congress set up, under which the CFPB gets its funding by drawing annually from the Federal Reserve System up to 12% of the Fed's annual budget, is unconstitutional. But of course, that's precisely the same funding design that the Fed itself has, and it is not distinguishable from the funding design of other financial regulators. Even the challengers in this case in the Fifth Circuit barely made this argument. The argument was an afterthought, a throwaway. The industry association representing the payday lenders spent no more than 368 words in their opening brief on this issue in their brief below. In another case, the Fifth Circuit considered the issue but declined to reach it. Perhaps because the issue wasn't extensively briefed or argued in the court below, the Fifth Circuit's analysis is shockingly thin in proportion to the gravity of this legal issue and its practical implications. And I think the first thing to start with is just the text. It's always best to start with the text of a constitutional provision. I read you the text earlier. Remember that that clause just says that money shouldn't be drawn from the Treasury unless Congress says so. But here, the money isn't coming from the Treasury, it's coming from the Fed's income. It's funded in precisely the way that the Fed is, and nobody has ever suggested that that is unconstitutional. And Congress has said that it wants the funding to be done this way. And in fact, there is contrary text in the Constitution itself that, as far as I can tell, was never cited in the court below and never considered by the Fifth Circuit, either in this case or in the previous case that I mentioned. And that's the provision where Congress elsewhere gives, the Constitution gives Congress the power to, quote, raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. That's a specific temporal limitation on appropriation for armies, because Congress was concerned about having a standing army that was permanent. But if the appropriations clause already limited Congress to annual appropriations, as the Fifth Circuit suggests, then this clause would be superfluous. And this shows how strange it is for the court to have read a limitation into the Constitution that wasn't there. Finally, history. Despite coming from a conservative court that is sometimes known for championing originalism as a method of constitutional interpretation, this decision doesn't even attempt to show that there's any historical evidence that the appropriations clause was intended to function as a limitation on Congress's ability to effect ongoing appropriations or to allow agencies to be self-funding. And again, there's no previous decision in American history that suggests otherwise. I'll just briefly touch on the implications. Kathleen and Dahlia will talk about them much more. The implications here are vast and they matter for American consumers, but I'll just stick to the law. In other constitutional challenges to the CFPB, there was an easy fix. You could sever the offending constitutional provision. That's what happened in the Supreme Court in the Salia Law decision. But you can't just sever the funding provision or mechanism of the CFPB. Under the Fifth Circuit's logic, if it's allowed to stand, everything that the agency has done and will do is potentially subject to legal attack unless Congress can step in and modify the funding structure through legislation. The recipe, in other words, is legal chaos, inviting everyone regulated by the CFPB to mount legal challenges. And indeed, in just the few days since the decision has been handed down, that has already started in cases across the country, and I expect that to continue. So I'm happy to answer any questions in the Q&A, but I'll turn it over to my colleagues now.
Thank you very much, Deepak. For the next, our next panelist, it's a nice segue. Deepak mentioned the uncertainty factor here. It is true that sometimes uncertainty gets thrown around by industry lobbyists as a reason why they shouldn't do X, Y, or Z on behalf of consumers. Nevertheless, this issue is real, and it becomes all the more real when a particularly crazy set of judges decides to pull the rug out from under things in this manner. We are fortunate to have with us Kathleen Engel, a professor at Suffolk University. I always want to say college. And Kathleen is a fantastic national authority on, I would say, almost all things mortgages, with a lot of other things thrown in, but all things mortgages is good enough. I think Kathleen would agree for a lifetime scholarship. She wrote a book that was appropriately named The Subprime Virus, about the housing and financial crisis of yore, which wasn't actually that long ago, but in many minds is rather distant now in the past. And I particularly enjoy that Kathleen was also the Associate Dean for Intellectual Life for a time at Suffolk University. This is a reminder that what many of us do, certainly what you do, matter, which is that ideas matter, and that it's important to think rigorously about these issues. So with that, I will turn it over to Kathleen, who will talk a little bit about the impact of this decision on the marketplace.
Thank you, Carter. The two words that come to mind when I think about what's happened as a result of this decision are uncertainty, which Carter already mentioned, and the other one is chaos. It's chaos because this decision calls into question thousands of regulations that the CFPB has issued, some of which they were actually issued by prior agencies like the Federal Reserve Board of Governors, and then were passed over to the CFPB in the Dodd-Frank Act. And this challenge to a single regulation has meaning for all the regulations. And if this decision stays, it's going to create tremendous chaos in the markets. And we're already seeing some signs of that chaos. It is not just consumer advocates and people who care about the situations for consumers who are shouting out these alarms. Several years ago, in a brief to the U.S. Supreme Court, a number of different organizations that are linked to both financial services industry and also to things like the real estate industry made the point that it would be catastrophic if the Supreme Court were to unravel regulations that the CFPB has put into effect. In fact, in one brief, they said, if the court issues a ruling calling into question the ongoing legitimacy of CFPB's past actions, the result could be catastrophic for the real estate finance industry. And we know that this is happening. As I mentioned, first of all, borrowers make decisions about securing credit based on trust, whether they believe that they are getting a fair deal, that they want to be sure that they won't be at risk of exploitation. And in research that I've done with other people, we actually saw that in response to state laws protecting consumers, the applications from consumers went up after the laws went into effect, and the quality of the applications went up as well. So we know that consumers care about whether they're being protected. Well, this decision has the effect of tearing away those protections that the CFPB has provided to consumers over the last decade. And for those of you who are less familiar with the effectiveness of the CFPB, the Bureau has secured over $14 billion for American families who were in some way exploited by financial services actors. So lenders are going to be, borrowers are going to be hesitant to borrow, and lenders are going to be hesitant to lend because they don't know what rules apply. And they don't want to take actions that might in the future be illegal or that are potentially illegal now. They're functioning in a vacuum. And that's hugely problematic, particularly at a time when applications for loans are going down, interest rates are going up. This is going to be another force that could reduce the activity in the mortgage market, which is fundamental to the operating of our economy. The other thing is that there are these important provisions which we call safe harbors. And safe harbors in this context exist to protect lenders and other entities in the financial services market. And what they do essentially is say that if an entity follows certain rules that the CFPB has laid out, then the borrowers are limited in their ability to sue the lender for wrongdoing. Well, just as the rules protecting borrowers have been struck down effectively by this decision, so too have the safe harbors that benefit lenders. That's going to make lenders reluctant to lend because they are more exposed now. And to add to that, they are most lenders are selling their loans on the secondary market through a complicated procedure called securitization. They basically morph the loans into bonds that are backed by the loans. Well, they only want to buy the loans if they know the risk they're taking on. And of course, they can never know their absolute risk, but what they do is they spend a huge amount of money and use a lot of technology to determine what the risks are associated with each individual loan. And the only way they can engage in that process is if they know what the litigation risk is, what their legal risks are. And now they don't know, just like the lenders. And on top of that, they may be holding loans in those securitizations that no longer have safe harbors. And that has the financial effect of devaluing the loans. Because if the holder of a security knows that those loans have defenses if the borrower brings a lawsuit, and those defenses then disappear, the risk goes up to the holder and the value of the loans and the underlying the securities, and the securities themselves decrease in value. So we could see log jams all over the place. Log jams where borrowers don't want to take out loans, lenders don't want to lend, and the secondary market actors don't want to buy these loans, all because they don't know the risks. And that's why it is that even people in industry said that if the CFPB is decimated by a ruling like this, it's going to be utter chaos in the markets. And I anticipate that's going to come. And then the last thing I want to say is that it's rare for consumers and financial services entities to be on the same side. And we are right now. From the people who do renovations of new homes, to the real estate brokers, to the lenders, to Wall Street, we are all facing a terribly chaotic situation in a very short time, and we're together in this.
Thank you very much, Kathleen. It's a great note to end on. One thinks, for example, of something like the Food and Drug Administration. Is it there to make sure that we don't swallow pharmaceuticals that will kill us? Yes, of course it's there. But one other effect it also has is to sort of bless the good pharmaceuticals that are effective in treating illness. And in much the same, CFPB functions in much the same way. By creating clear rules of the road, it works for consumers and it works for businesses. We can talk a little bit more about that in the Q&A. One person has already started to put something in the Q&A, and I would encourage people to go ahead and start putting them in. They don't disappear, and we can, but we can go back to those later. But I know you might have something on the brain from what Deepak said or what Kathleen said, so feel free to jump in there. Now, that having been said, we do have another great panelist here. Dalia Jimenez is another one of those legal eagles who was also in the trenches at CFPB. And when I say she was in the trenches, I really mean it, because she was founding staff, which if you listen to anybody about what it was like to start up the Bureau, it was a real pressure cooker. It was a furious year between when Congress passed Dodd-Frank and when CFPB started its work, an extremely successful period, thanks to people like Dalia. She is, in her real job, so to speak, a professor of law at UCI Law, and is the director of its student loan law initiative, teaches all sorts of courses in bankruptcy, contracts, transitions, consumer law, and any number of professional affiliations that we would all find quite impressive. And Dr. Jimenez was also born in Cuba, but found her way to the law via, I recently learned, a degree in what was it? Computer science and electrical engineering. So there's no telling where life takes you. Dalia, take it away.
Thanks, Carter, and thanks for inviting me. It's a pleasure to be here with Deepak and Kathleen, where I've learned tons from them already. The CFPB gets attacked because it does its job, because it does it well, not because it's doing something unconstitutional or wrong. These attacks are merely pretext, as Deepak explained so well earlier. But the Bureau has been highly effective at protecting consumers and extremely effective at stopping illegal behavior in the marketplace of consumer financial products and services. The facts speak for themselves. Unlike many regulators, the Bureau doesn't just stop bad behavior with its enforcement actions, it actually gets things for consumers. Kathleen mentioned, but through 2021, over $13 billion in consumer relief was handed or offered to more than 175 million people. This is monetary compensation, principal reductions, canceled debts, so direct, money or money-like things in consumers' pockets. And separate from that, the Bureau obtained over $1.8 billion in penalties. That's actual making a difference. They've also taken over 3 million complaints, consumer complaints about violations of law since it started in 2012, and actually since it ramped up slowly the consumer complaint system. More than half of those were actually taken in the last 3 years. Of note is that the majority of people get a response from a company that they're complaining about within 2 weeks, and most people have a very high satisfaction in terms of their complaint being solved or them feeling like at least they were heard. In the supervision area, these are just some of the examples of the things that Bureau has done. In supervision, they've provided guidance and certainty for industry in the form of both public documents and just as part of the private supervisory guidance. The chaos caused by this decision is undoubtedly currently slowing down the CFPB's important work, and that is partly its design, right? Like that is partly the point here. Staff must be spending, and I'm fairly certain are spending a lot of time figuring out what it is that they can and cannot do, how they should essentially change what they've been planning to do, potentially having to stop some rules or enforcement actions or supervision exams. Already, at least 3 companies are challenging the CFPB's right to sue them at all for violations of consumer financial protection laws. TransUnion, a credit repair company, and I just heard of a company that's accusing that the CFPB is accusing of violating the Civil Service Member Civil Relief Act, and they're claiming that because of this decision, the CFPB shouldn't be involved in enforcing the laws. This is likely to happen in several more enforcement actions as companies seek to slow down the Bureau or to gain an upper hand in negotiations. Obviously, diverting the Bureau away from the resources of the Bureau away from its job of protecting consumers. And the 1,500 or so employees, and that's how many employees the Bureau has. It is not the thousands and thousands of lawyers that are on the other side representing, essentially the regulated entities. The 1,500 employees that work at the Bureau, they just want to make financial markets fair for everyone and protect consumers. Since I worked in the Research Markets and Regulations division, I'm going to close with a list of very important rules that the Bureau is currently working on, including several rules regarding the mortgage markets, the qualified mortgages, which are the backbone of the mortgage market, as well as refinance and forbearance issues, credit card late fees and payments, rules around debt collection, and consumer access to financial records. This extreme decision is already having a dramatic impact in markets, as Kathleen explained, and it will have a severe and negative impact on consumers if it's allowed to stand. And I'm looking forward to hearing your questions and answering them. Thank you.
Very good. That is a lot to digest from 3 very smart people. So I am going to start. Please do put any questions you have in the Q&A function of Zoom there. We decided chat would be just sheer anarchy, but the Q&A function seems to work pretty well. I would also encourage any journalist who is on, who has a question, to please chime in. We did want to make sure media got a chance to get their questions answered. Just indicate that in the Q&A and I will sort of pull you up in the queue. But I am going to start with a question that I'm gonna send to Deepak from Brad Blower. not sure we are all on this. Well, it's a little bit of Deepak and Kathleen. Not sure we are all on the same side. Can you also address the Chamber Consumer Bankers Association and the American Bankers Association included the same argument attacking funding in their attack on the CFPB's application of unfairness to discrimination? So Deepak, do you want to take first crack at that, or Kathleen?
Yeah, I mean, I think that might be more directed to Kathleen, but I will just say it is true that this argument has been made by industry groups in the past. I didn't mean to suggest otherwise. It's been made among a suite of arguments attacking the CFPB. There's been, sort of at least 10 different flavors of separation of powers attacks on the CFPB since its inception. But this argument has been routinely rejected. And so until now, nobody has really had to grapple with the practical implications of a court actually taking this argument seriously. And I think, this may be a question, a situation of the industry being careful what it wishes for, because, this one sort of fringe part of the consumer financial marketplace, an industry group representing the payday lenders, has now gotten the court to accept an argument that affects the entire consumer financial marketplaces. And I think, as Kathleen persuasively explained, there are industries that are taking advantage of safe harbors that will now not be able to do so potentially. And the one thing that the banking industry and the consumer finance industry craves more than anything else, perhaps, is regulatory certainty, and they now don't have that. So it's true, the questioner is right, that industry groups have made this argument among a suite of arguments in the past in attacking the Bureau, but I question whether, for example, the American Bankers Association is really celebrating this week.
Kathleen, do you want to chime in on that one?
Well, I just want to, I agree completely with what Deepak said. And, like all of us, we make the arguments that suit us best in this situation. You think about it, even in parenting, you aren't always consistent. And the same holds true for the financial services industry. They didn't have much to, or really anything to lose in the case that Brad Blauer mentioned involving unfairness being used as a way to attack discrimination. But here they do have a lot to lose. And to give you a sense of just how much that is, the brief that I was quoting from in a different case, it was entered into by the Mortgage Bankers Association, the National Association of Home Builders, and the National Association of Realtors. So 3 different industry actors all came together in this brief, and it's 10 pages long about how dismantling the CFPB would cause massive disruption to the economy, to housing markets, to financial markets. So they certainly thought it was incredibly important in this case, which means they have a lot to lose, and otherwise they wouldn't argue this. So the consumers are losers with this decision, and so is the larger financial industry and the economy as well.
Thank you very much, Deepak and Kathleen. I'm going to go to the next question here from Carolyn Carter, which is that one ground of the decision had to do with the money that CFPB rolls over each year. Is this possibly a way to cure alleged unconstitutionality by eliminating this ability to roll money over?
So I guess the suggestion would be that Congress would do that. I think that
Is
yes,
it possible to sever that aspect of CFPB's funding mechanism?
it doesn't seem to me that the decision rests only on that ground. I think the decision is more sweeping. It seems to rest on the idea that there is this temporal limitation on appropriations and that it's double insulated. So I'm not sure that I would take much comfort in the idea that there's any kind of fix other than at least immediately now the need for the Supreme Court to stay the decision.
Okay. We have another question here from Stephen Hall of Better Markets, I believe. What is the scope of the Fifth Circuit's decision? Must the CFPB accept the ruling only within the geographical area covered by the Fifth Circuit or throughout the entire country? I guess this is what happens when you have a crazy Fifth Circuit trying to make law for everybody, but I'm sure you'll clear this right up, Deepak. Go ahead.
That's a good question. So with respect to the payday lending rule that was enjoined in this decision, I think that the Fifth Circuit will have to adhere to that decision nationwide. In other words, I don't think that the CFPB is going to seek to do anything with respect to the rule elsewhere in the country. But it's true that this is precedent only within the Fifth Circuit, and there's now a circuit split because the DC Circuit directly rejected this very argument in the PHH case. And this decision is not the law elsewhere outside of Texas, Mississippi, and Louisiana. And that is precisely the sort of situation in which the Supreme Court needs to step in, where you have nationwide programs that are subject to completely divergent legal regimes.
Thank you, Deepak. Let's see. I'm gonna okay. Nicole Cabanes. Could one of you speak to what this decision means for the CFPB from an administrative law perspective? Does this mean that any agency action by the CFPB in the Fifth Circuit is invalid or unenforceable? One of you legals has administrative law expertise, but I'm blanking on, was it Kathleen or Dahlia?
I think actually it's Deepak.
Why don't I take the first stab, and then if anyone wants to jump in. So the question was, from an administrative law perspective, what is the effect of this decision on other actions that the agency has taken? And this is the big question now, because as I mentioned earlier, there are already attempts in ongoing litigation to invoke this decision, not just in the Fifth Circuit, but elsewhere. Just as troubling as the substantive constitutional reasoning of this decision is the remedy discussion in the opinion, because it really has no limiting principle. The rationale is that these challengers have standing and can seek a remedy so long as they're harmed by the funding structure. But the Fifth Circuit reasons that they're harmed so long as there's an action that was taken by the agency that could have been funded in the way that the CFPB is funded. Well, that really means everything that the CFPB has done or will do. And so it really opens up everything, every rule, every guidance, even as I think Kathleen said, things that came originally from other agencies at the formation of the CFPB. All of those things are now potentially open to attack without any real limiting principles in this decision.
Yeah, I think I would just add that the limiting principle it espoused regarding anything that's been funded with through the Federal Reserve isn't even, they really didn't analyze this deeply, as for the reasons Deepak explained. It wasn't actually really briefed, but actually the CFPB had for the first 3, 4, 5 years appropriations from Congress, right? And so they actually would have spent some of that money. There was no attempt here to do any kind of tracing with regards to whether any of that money was used in this decision. I mean, I don't know how you would possibly do that, but that is something that the court completely ignored here. They also really, I think, so from the administrative law perspective, I think it calls into question basically everything, which is what we've been using words like chaos, mess, all of this, right? But it doesn't immediately do that, right? Like it's the decision, the reasoning does that, but the decision itself, should not, I don't think, affect, there's nothing commanding the Bureau, to stop what it's doing because of this decision. But it does basically allow everybody to now use this reasoning in their cases and in larger arguments. But the other thing that's really dangerous about the decision that we haven't talked about, because it's about the Bureau, but it is much broader than the Bureau. The reasoning is actually calls into question the Fed's own funding structure. I mean, it just, they have very, very little limiting principles, which is what makes it so dangerous.
I'm going to slide in a question here for Kathleen, because I think Dahlia alluded to this, which Dahlia says, This allows everyone to use the logic of this ruling. Kathleen, suppose I was a consumer, a customer of a big bank in the Fifth Circuit. Are there ways that I, as a customer, could find ways and say, sort of, oh well, that safe harbor is no longer invalid, so I could go after this bank. I mean, does how does that how might that expose a bank to litigation from its own customers?
Sure. There's this thing called a qualified mortgage, and and essentially what it does is it limits, and sometimes, depending on the situation, can totally insulate a lender from liability if they make loans that comply with the standards that the CFPB has set out, which are mostly about affordability. So instead of getting too legalistic here, if you make a loan that under the regs is presumptively affordable, then the lender can be immune from certain lawsuits. So that means that your hypothetical borrower could go into the bank and say, I want you to make me a loan that's affordable based on the CFPB regulations, and I recognize that you're still going to be on the hook. That's how it's going to work. And again, as Dahlia pointed out, I think it was Dahlia who did, we're only talking about 3 jurisdictions right now, but that doesn't mean that the decision is without influence in other states, because the industry is going to be worried about what's going to happen. The case that Deepak mentioned, the Justice Kavanaugh was I'm sorry, that was the Celia case. I mixed up 2 cases, but Justice Kavanaugh has written in a decision from the DC Circuit that he is opposed to the funding structure of the CFPB, and he's on the US Supreme Court, as we know now. So there is a real risk that he may go along, as he's generally done, with the conservative part of the court. He may not too. There's some evidence that he too is concerned about the chaos that defunding essentially the CFPB would cause. So the bottom line is in Texas, Louisiana, Mississippi, we sort of have an anti-law, right? That's kind of the effect, because we don't know what the law really is now. And in other parts of the country, we have fear. What does this mean? Are we going to lose the CFPB altogether? What does it mean about the regulations? If this happens, if the Supreme Court upholds the decision out of the Fifth Circuit, we are going back in time to a period of time before there was consumer protection in this country, right? Because we're going to lose all of those regulations, and we'll be back to, like, I don't know, the only thing we'll have is powers that were given to the Federal Trade Commission. So it's not simply reversing the CFPB's regulations or obliterating them. It's a situation in which there is no regulation to protect consumers.
Excuse me. I am now going to go to a question from Stephen Hayes, who is going to throw Deepak Gupta the easy pitch, which is to predict the Supreme Court and the course of this litigation. Is it likely that CFPB will skip on bank review and go straight to SCOTUS? If so, is there any chance of a stay through the shadow docket, or will this be traditional cert? Okay, how much jargon can we pack into one?
Yeah, I'll try to answer the question in English for non-lawyers. So, look, I think there's no question. I would be shocked. I think there's no question that the Solicitor General's office, the office within the Justice Department that represents the government in the Supreme Court, will be seeking review of this decision. Traditionally, you would seek what's called en banc review. You would seek review by the full Court of Appeals, probably. In this case, I think there'd be good reasons to skip that step. If you count the votes in the Fifth Circuit, you include the votes in this decision that just came down, along with the decision by one of the judges there, Judge Jones, who adopted this theory before. and you add up all those votes, that's almost half the Fifth Circuit right there. So I think there's a good reason to skip and go straight to the Supreme Court. And as I said, there is undoubtedly a circuit split and an immediate need for relief that only the Supreme Court can provide, which is national relief, given the litigation all over the place. So I think what I would anticipate is that the Solicitor General's office will do two things. They will seek a stay, hopefully very soon, of this decision. And then they would also indicate that they're going to ask the court at the earliest possible opportunity to hear the case on the merits, on its argument docket. And I think it is still possible for the court to do that within this term, and there's some precedent in important separation of powers challenges for the court to expedite the case. So, I think the Supreme Court needs to take very seriously that there should be a stay, regardless of kind of what you think about how the court's going to come down. This is just the kind of decision that needs to be done in an orderly fashion, because as we've hopefully persuaded you, there's a lot of chaos in the near term, and it doesn't make sense to have that go on if the court is ultimately going to take a different position on the merits.
Okay. Thank you, Deepak. Nadine Chabrier asked a similar question: what would the CFPB request for a stay look like? So I think you pretty much covered that one. Let's go to one from Stephanie Duhay. I hope I'm pronouncing that correctly. Does a higher court need to uphold this decision for chaos to occur? So we'll send that one to Kathleen, and do keep your questions coming. We still should be able to get to a few more.
The shorter answer is no. The chaos is brewing, as we've seen with the new cases that have been filed, and for sure there's some very intense conversations happening at banks and other lenders throughout the 3 states that this decision covers. Certainly, there's also the sort of the smoke of the fire is drifting to other states as well because of the uncertainty that we've all been talking about.
Yeah, and then the one, in these states, we have things we have already said, talked about safe harbors and how they, they're really there to, like the QM rule, to protect businesses, and they are, in question, especially in the 3 states in the Fifth Circuit. And so we have things like the debt collection rule, which was finalized not long ago, a year and change ago, which includes a number of safe harbors, like ways in which debt collectors can text people, which they really wanted, and they can leave voicemails for people in particular ways, such that they don't violate the Fair Debt Collection Practices Act. Those are ones in which consumers can actually use the uncertainty to their advantage, I suppose. But the chaos is current and ongoing.
Thank you, Delia. I'm gonna go to a question from Carolyn Carter here for something that Deepak sort of flicked at, but I think is worth going into a bit more clearly, which is, do any of the panelists have comments on whether the allegedly unconstitutional funding inflicted harm? The Fifth Circuit's reason on this seems particularly loose. I'm looking at Deepak. Is he?
Oh, I'm sorry. Yeah.
Okay.
Yeah, I think that the Fifth Circuit's reasoning, I mentioned this earlier, the Fifth Circuit's reasoning is pretty thin, and their understanding of harm is simply, well, are you challenging something, in this case, the sort of whatever is left of the payday lending rule that was arguably funded through this mechanism. As Dalier already explained, they didn't even really carefully analyze that question, right? Because they didn't actually, I think maybe because there was no briefing, I'm not sure the court even knows that there was $200 million of funding, for several years through the appropriations process. But beyond that, there's no analysis of how these payday lenders are actually harmed. The rule is not really in effect. The Trump administration never let that rule go into effect, and it hasn't been in effect this whole time this litigation has been pending. So it really does seem like this is an abstract, it's not really a real case, and it's questionable whether there's really standing or a case in controversy here, but the Fifth Circuit didn't analyze any of that.
Thank you, Deepak. Let us go to a question from Laura McCleary, which is again, prediction, what will SCOTUS decide? But I'll rephrase that slightly, Deepak, to say that we have come accustomed to thinking of this Supreme Court as being willing, at least 6 members of it, willing to embrace just about any radical right-wing argument that they come up with. Is it possible that this is a bridge too far for some members of the dominant conservative faction on the court?
Yeah, I do think so. I think, look, this is not it's not a set of issues that the court hasn't thought about already. There was extensive briefing and consideration in the Celia Law case before the Supreme Court about the structure of the CFPB, and the court took, a measured approach. They didn't destroy the agency. They took a measured approach in the remedy, which is to say the agency can continue in its operations so long as it doesn't have this for-cause removal protection in the statute. And so it would be quite strange after all these years of all this fighting about the CFPB for this new argument to come in and to have a much more sweeping kind of practical effect. And Kathleen mentioned Justice Kavanaugh's opinion. I don't see a lot of evidence that is shared across the court. And I think the court has to be concerned about coming up with a theory that has some limiting principles, because the Fifth Circuit's decision doesn't explain persuasively why, if you adopt this theory, it doesn't doom the funding stream for the Federal Reserve and for a bunch of other federal regulators. They have this theory of double insulation, the idea being that, well, the CFPB gets its money from the Fed and the Fed is insulated, so that's double insulation. And it doesn't really make any sense if you think about it for even a moment. You're either appropriated or you're not. And this is not appropriations funding, and it's precisely the same funding mechanism as the Fed. So unless the Supreme Court is prepared to say that the Fed is unconstitutional, they're going to have to come up with some different theory from the one the Fifth Circuit adopted. And I just don't see that ultimately having 5 votes, or at least I wouldn't be so confident that that's the case.
Thank you, Deepak. Laura McCleary had a follow-up here that I'm going to answer, which she says, is there a way, however reasonable or unreasonable, for the court to distinguish between the Federal Reserve's funding mechanism from the CFPB? The short answer is no. For a longer answer, I would highly recommend a blog that Professor Adam Levitin of Georgetown Law Center wrote for the blog Credit Slips, Laura, which the subheading of his blog is the supposed problem with CFPB funding. That tells you a lot, but the short answer is, there's an assessment on regional banks that funds the Fed, and the CFPB gets part of that money. And so, no, not really. There's sort of some Fed income related to its capital markets operations, but that is to a great extent a function of its immense intervention in financial markets over the past decade. We have Larry Kirsch. Why do you think the industry brought this suit in view of their substantial concerns about regulatory uncertainty? I suppose we could paraphrase that question as, are you saying that the industry is a bunch of hypocrites? Who would like to take that, Kathleen or Dahlia?
I can start. I'm sure Dahlia will have more to add. This suit was brought by payday lenders. And as far as I know, the payday lenders don't have anything to lose if the regulations governing them are struck down. I don't know of any safe harbors in there, but that's something I think Dahlia can answer better. So they're different. They're in a different position than, say, creditors who make mortgage loans and things like that, or debt collectors. So that may be one reason, but I'm just speculating. I don't know what's in their heads. But Dahlia may have more informed insights.
Yeah, I suppose it is, it is only a group, right? And a few that have signed on that brought this on. It's not the entire industry. And I can imagine that the industry, sort of overall, they're, they fall on several camps, right? Like at one end, it might prefer, if it all kind of blows up, then no regulation, make lots of money. In the meantime, what the industry doesn't say about uncertainty when they complain about it is that uncertainty is overall fairly lucrative because it all, the only way it's not lucrative is if the Bureau basically sues them, because the consumer remedies are so limited in most of these spaces, and the incentives and just financial ability of consumers to sue for violations of law is so limited that essentially it works in their favor when all is said and done. So yeah, to your point, Carter, I mean, when it's convenient, uncertainty is bad. Otherwise, it's fine.
Anything to add, Deepak?
One other thing, yeah. I would just say also the payday lending industry brought this in as a challenge to this 2017 regulation, and I think I mentioned this just briefly earlier. This funding challenge was really an afterthought. This was, they barely mentioned it. So they were making a whole bunch of challenges that were focused on the rule, and what you have is an activist panel that reached out to grab this constitutional theory. So I think I would bet that even the payday lending industry lawyers are surprised this happened.
Yeah, and to which one can add also, I think there's a lot of people in here that have had experience with the payday lending industry, which is you sometimes find froth at the mouth and bile, and somewhere down the list is actual legal reasoning. I mean, they viscerally hate CFPB, so they think less than other actors, I would say about keeping things orderly in the markets. If they view themselves as having a target on their back, therefore we're going to do whatever we can, and the opportunities outweigh the risks. I'm going to make a last call for questions. Oh wait, we got one. What is okay? April Kuhnhoff, what is your advice to someone who wants to file an affirmative claim based on one of the CFPB's regulations? Are there any pleading strategies to minimize uncertainty? So we've now entered the part of the webinar entitled Free Legal Advice. Which one of our panelists would like to go first?
Here's just one idea, picking up on something that both Dahlia and I have mentioned. I mean, I suppose you could say, you could, if you can plead upon information and belief that the Bureau's operations relied in part on appropriations funding, you could say that it's not clear that the regulation that you're invoking was not supported by appropriations funding, and then that becomes a factual question.
Any other panelists' comments? Okay. I'm going to, we have a last question here from Beverly Brown Ruggia, New Jersey Citizen Action, a great voice on the ground in New Jersey for justice and consumer finance. What, if anything, can consumer advocates do to respond to the court's decision? Are there specific things we should be asking Congress to do to protect the Bureau and its funding if the decision stands? Now, I have a communicator's answer to this question. I'm going to chime in, but let's ask first of all, maybe for our lawyer friends here, how do we as advocates sort of buttress the legal claims that are going to need to be made here? What's helpful to the legal process?
Get the word out. It matters. It matters that people understand what's going on. I've been a little shocked that there hasn't been as much press and as much discussion in the news about this decision and the chaotic effects it's going to have. And so I think it's really important to advocates get the word out and make people understand that. When there's public opinion polling about this agency, it is an extremely popular agency for all the reasons Dalier explained. It has done so much for American consumers. And that's a nonpartisan opinion. I think that people of all political persuasions believe in consumer protection. So we have to get the word out there that this aggressive, unelected court has done this thing that nullifies action that Congress took to protect American consumers. And then if it comes to it, I'm hopeful the Supreme Court will stay this and this will go away. But if not, if it comes to it, then there will have to be a fight in Congress about the future of the agency.
And just to add one other thing is that it's easy to look at this decision as a legal decision, but that isn't what it is. It's an ideological decision. And it's part of a campaign, really, a general campaign to get rid of the regulatory state, which is what we have and most democracies have, and also to undermine the CFPB, hopefully to eliminate it. And we're seeing it in other areas too, where the uber conservatives are trying to stop the student loan relief package that President Biden has orchestrated. And I think that there's a general comment is get out and vote. You are being represented by people who are trying to do everything they can to be sure that the rich get richer and that the federal government loses the power to protect the people.
Thank you, Kathleen. Thank you, Dahlia. Thank you, Deepak. So that's a good note to end on it, which is that we all need to do what a lot of people have been doing for 10 plus years, which is stand up for the CFPB. We want Congress to know that this is an agency that people want, that protects people. It's not something, it's not just another collection of letters in the alphabet soup of federal agencies. So to the extent that they know that, they defend it. It's how CFPB was created and how hopefully it will continue its good work. Thank you very much to all our panelists. Thank you to Isis, William, and Maria lurking in the background here for AFR for handling the sort of technical side of things. It's been extremely informative. There will be a recording of this that we will circulate, and there will be no doubt much discussion on the ubiquitous listservs. Thanks very much, everybody.